Good afternoon. Welcome to Estate Planning with Aging Parents. We're going to go ahead and get started, and we're so happy to bring this content to you, sponsored by the King County Library System. I'd like to begin by saying that People's Memorial Association would like to acknowledge the traditional, ancestral, unceded territory of the Coast Salish, Duwamish, and Suquamish nations on which we work and live. Though we are physically located in the city of Seattle and most of our staff live here, we do serve the entire state of Washington. Before we begin today, I have a couple of housekeeping items. We're going to go ahead and have all of our participants keep themselves on mute just to cut down on a little bit of the background noise. We're going to go ahead and record today's session, so don't worry too much if you don't get all your notes down just in time. We'll make sure that that recording is available to you after the presentation today. If any questions pop up for you, please feel free to drop those into the chat box. And if you're maybe a little bit on the more shy side, feel free to go ahead and send your question directly to myself or Amanda Stock, and we'll be happy to ask your question anonymously. And just in case you don't know quite exactly what your question is and it comes up a little bit later, we'll also make sure you have our contact information as well as our presenters, and so you can go ahead and ask those questions a little bit later on down the line. If this is your first time joining us, welcome. My name is Beverly, and I'm the Communications Manager at People's Memorial Association. In case you didn't know, we are the oldest and largest memorial society in the United States. We were founded in 1939 right here in Seattle. We are the only nonprofit in Washington that provides funeral education and advocacy, though we are part of the National Funeral Consumers Alliance. So if you're joining us from out of state, we might be specific to Washington, but it's distinctly possible there's an affiliated organization a little bit closer to your own home. As of now, I think we just broke the limit on 215,000 members that have joined in the 81 years we've been around. And of those folks, about 70,000 of those folks are still living. So we keep ourselves pretty busy in the office serving a really robust membership. And just a couple things to keep on your radar. This is part of a theme series that we've got here in November for supporting the supporters. This course is geared towards folks that are caring for their aging parents. We know that a lot of the families that we serve and a lot of the families that are served by our funeral homes, ultimately the care is being handled by kids. And we want to make sure that folks have the information they need to support their parents as much as possible. So after today, tomorrow we're going to have a session about advanced care planning, and that's going to be specifically about healthcare directives. And we're hoping to be able to reschedule our voluntary stopping eating and drinking case study to a later point in time. But we'll keep you posted, and don't worry if these don't line up with your schedule. We are putting our recordings up on our webinar library on our website. I'm really excited to bring to you Michael Harkovich. He's a librarian from the King County Library System who is sponsoring this little webinar here that you're on. Do you want to say a couple words there, Michael?
I just wanted to say welcome to everybody. This is, like she said, this is sponsored by the King County Library System, a collaboration with People's Memorial Association. And I'd like to thank both Amanda and Beverly for setting this up for us. And thank you to Elizabeth for being here and presenting us with this wonderful information.
Thank you so much, Michael. So I'm going to go ahead and pass it on over to Elizabeth Jennings. She's joining us here from the Northwest Elder Law Group, where she is an attorney. Thank you so much for joining us, Elizabeth.
Hello, thank you all. Thank you for joining. I know we all have a lot of time at home these days. So what better time to talk about estate planning and kind of build your knowledge base so you can start to have those conversations with your parents or loved ones, maybe looking at estate planning yourself. So today I'm going to give you a broad overview of estate planning, the reasons we do it, types of documents that may be in kind of your tool chest, and things that you should start to think about if you're starting to have these conversations with your parents, with family members, maybe with your spouse, to kind of get all these unfortunate legal issues and documents out of the way. So today I'm going to kind of cover three big areas to think about. Planning for death, probably not the most exciting or positive topic to finish off your day. but really important and what people commonly think of when it comes to estate planning. I'm also going to talk about planning for incapacity. So very often family members, children are having to step in and care for their parents or other family members during periods of incapacity when maybe parents aren't able to make their own decisions. And then lastly, we're going to talk about planning to live a long time, right? How do you have conversations with your loved ones about the expense or the financial implications of receiving long-term care? Kind of what does that look like? So I'm going to cover a lot in a short period of time, but please know that there are some great resources out there to kind of dig into these topics more along the way. So I know planning to talk about death and passing away and estate planning isn't usually what people want to do, especially around the holidays as we're talking with loved ones. But I like to think of this part of the discussion as planning to put your priorities on paper, right? And having those conversations with family members about what kind of gifts do they want to leave for loved ones after they're no longer here. So I'm going to talk a little bit about ways that we may do that and kind of use this as a checklist if you're having these conversations with loved ones. What kind of estate planning plans do they already have in place, and where do they maybe need to do a little bit more work? So I'm going to talk about probate and non-probate assets. We'll touch a little bit on the probate process, which I know can be a mystery to a lot of people. And then we're going to look at some common estate planning documents. So the first thing I always like to educate everyone on is think about what's in your estate, or what does a loved one own. So if you are single or you're talking to someone who is single, their estate is everything that they own. If you're talking to someone who is part of a couple, right, they're married, then that can be a little bit more difficult. So if someone is married, their estate covers not only the separate property that maybe they brought into the marriage, or inheritances or gifts that they received during their marriage, but half of the community property that they've accumulated during their marriage. So Washington is a community property state. Once that marriage clock starts ticking, anything that is acquired, kind of income and earned and accumulated during marriage may be community property. And so when you're doing estate planning, someone can gift away all of their separate property and half of the community property in their estate. So important to keep that in mind. There's also kind of some subcategories of property that someone may own. We have probate assets, which is this kind of big general category that means anything that someone owns that doesn't have a designated pay on death beneficiary. And then we have non-probate assets that you may have in your own kind of wealth portfolio, assets that you have already designated a pay on death beneficiary. And I get a lot of questions from clients saying, I want to avoid probate completely. I've heard it's horrible. One way to do that is to make sure that everything you own is a non-probate asset that has a designated beneficiary or is going to transfer outside of a will or outside of the probate process. So that's a point of conversation as you're starting to talk with loved ones or parents about kind of what's in their estate, what do they own, how is it held, taking a look at what assets are out there that are maybe non-probate. So you can have joint ownership with property that's owned as joint tenants with right of survivorship, which essentially means whoever co-owns it, whoever lives the longest is the owner of that property after the other owners pass away. You may have pay on death bank accounts, beneficiary designations on retirement accounts, and then we're going to talk about trust instruments as well. So this can be a helpful maybe point of conversation as you talk to loved ones Have they looked at beneficiary designations on bank accounts and retirement accounts? Now is a good time, right, when we're all at home during the pandemic, maybe pull out that paperwork and see if anything needs to be updated. So I get a lot of questions about probate, and is it as horrible as you've heard? So probate in general is just the process of administering someone's estate. It is a court process, kind of court is going to oversee to make sure that someone's final debts and taxes are properly handled, and then that their estate is distributed according to their wishes. I get lots of calls from clients saying, I need to avoid probate any way possible, right? I've heard it's horrible. It can be in certain states. So we're lucky here in Washington. Washington has a pretty great kind of orderly, efficient probate process. And so I try to caution clients, don't worry so much about trying to avoid probate. Sometimes it can take a lot more work to avoid probate than just having to go through the probate process itself. So if you are named in a loved one's will or estate planning documents as the executor or the personal representative or someone in charge of handling probate, I just want to caution you, don't feel overwhelmed quite yet. So Washington is a pretty good process. Of course, if someone has property in other states, we'll talk about ways that that can be a little bit more difficult. One thing you can kind of bring up to loved ones, especially if you are named as their executor under a will, make sure that they have kind of done some of the advance work to make that process easy for you. So having a will in place is a great first step, right? It expedites the process and it makes sure that your wishes are very, very clear, not only to your personal representative or executor, but to your family members, to the beneficiaries. You know, everyone kind of knows what to expect when you have a will in place. It's also helpful if the person making that will keeps important paperwork together, right? So I've done this with my own parents. I said, hey, where do you keep all your important paperwork? Do you have a list of kind of every bank that you have a bank account with? Who does your taxes? You know, starting that kind of cheat sheet, making sure that everyone is on the same page about what's out there that may have to be handled in the probate process. And then my number one tip, have these conversations early. The more you have these conversations with your loved ones, there's no surprises, hopefully down the road. It can really avoid conflict and confusion in a very difficult time if you're having to handle the estate of a loved one. So this is your opportunity to kind of give a gentle nudge to loved ones out there, seeing if they have their assets, their estate in order, and also a nudge to yourself, right? It can be a great opener to a conversation as we talk with family members or our aging parents. To say, look, I just did my estate planning. Hey, do you have yours in order? Let's talk about it. So now we want to go through some common estate planning documents that you may run into or may be relevant for your own estate planning, or if you're trying to help a loved one like a parent with theirs. So one estate planning tool is called a community property agreement or a community survivorship agreement. And this can be a really helpful estate planning tool for married couples. So it's also a great way to avoid probate if one spouse passes away. As I mentioned a little bit earlier, Washington is a community property state, but we still may own, if you're married, separate property. So a community property agreement is an agreement between spouses that simply says, everything I own, I'm going to consider community property. And when I pass away, I want that to pass automatically to my spouse. So that can be a good conversation to start with if you have parents, seeing if they have a community property agreement or what kind of joint planning maybe they've done together. Probably the most common estate planning tool that you've heard of and you come across is a will. So at the very, very basic level, a will can be done by any adult who has capacity, right? They're of sound mind. They generally understand what's in their estate. They understand who they want to give that estate to. And so in Washington, it is required that a will be in writing. It has to be in writing. It can be handwritten or typed up, but it does have to be in writing, signed by the testator, the person who's making it, and their signature needs to be witnessed by 2 witnesses. And those witnesses should be disinterested, right? It shouldn't be people that you're giving your entire estate to that are also witnessing the will. And then ideally you want that will to be what's called self-proving, which means that there's a separate affidavit or declaration of the witnesses that kind of recounts the circumstances of the signing. So that if someone passes away and a will has to be admitted to probate, we don't have to go track down those witnesses, 10, 20, 30, 50 years down the road. So these are kind of the basic requirements that you maybe want to check if you're looking over a loved one's, their own will, if they hand it to you to kind of take a look at, can they check all these boxes? Most wills are going to have kind of core components, but then from there they can vary widely. So I'm going to talk about the most basic kind of will content that you may come across, but know that wills can be short and sweet, 1 or 2 pages, or they could be 20 pages long. There's really a lot of room for them to be customized depending on someone's wishes. And the most basic level though, a will is going to identify the testator, right? Who's making the will, and will usually identify their immediate family. Even if they're not going to gift to their family members, it can be really helpful for them to include who is their immediate family so that it's easy for notification in the instance of probate, so that we make sure we haven't forgotten someone, forgotten a child that we haven't mentioned in our will. You'll also see that there's usually a statement revoking any prior wills or codicils. So codicils are just amendments to wills, right? And so each new will, we want to make it clear that it's superseding any prior will that's been done. Someone can make a new will as often as they want, as long as they still have capacity to do so. So as long as you're alive and have capacity, you can make a new will. Getting into more of the substance of a will, sometimes you'll see reference to distributions of personal property. So this is an area where Washington is pretty cool. We have a statute that basically provides if you reference in your will or trust that you may have a separate writing gifting tangible personal property, as long as you reference that there's a possibility of that writing in your will, you can add to and update that separate writing as much as you want, as frequently as you want, without having to update your will. So this kind of replaces, like my grandmother did, saying write your name on a Post-it note and stick it on what you want in the house. It's a way that you can maintain a list of certain items, furniture, jewelry, artwork, whatever it may be, that's kind of tangible property that you can describe that item and who you want it to go to, and you can add to or change that list without having to update your will. Then we get into generally the gifting in the will. And when it comes to gifts, you're going to see maybe specific bequests, which are certain things or dollar amounts to certain people. Or you may see something like the rest, residue, and remainder, which is just legal terminology to say I give everything or everything else after all my debts are paid and all these specific gifts are given. I give everything that's left to this person or these 3 people in equal shares. A will is also going to nominate a personal representative, which is the same thing as an executor. Washington uses this more generic term of personal representative, but it's designating someone who is in charge of carrying out your wishes in the will. And it's something that I highly recommend that you have multiple people in there, right? So maybe you name one person as your personal representative, but if they're unable to act when the time comes, hopefully there's a backup or even a secondary or third backup named in that will. If you are someone who may be named as a personal representative in a will, you want to see if the will gives you non-intervention powers. This means that you are being named to handle the estate, and once you're appointed by the court, you don't have to go back to the court to get permission to take certain action. So non-intervention powers is a way to make probate a lot more efficient, cost-effective. So that can be really helpful to make sure if you're looking at your own estate planning or maybe a parent's estate planning, do they give you non-intervention powers when they name you as personal representative? You also may want to see if bond is waived. That means that you don't have to get kind of financial security to carry out the terms of the will. Really important that the will is actually signed in some way by the testator, the maker, and it's dated. And then witnesses are also signing the will, right? That they witnessed the signing of this will. And then the affidavit of the attesting witnesses usually details, when the will was signed, that they believed the maker wasn't under any duress, undue influence, wasn't forced to sign it, that they appeared to know what they were doing. So it's kind of the big components that you want to see in any will, but then you can always add a lot more. So if you are doing your own estate planning and you have children, you may want to make sure that you've designated guardians for any minors that you may have, right? If something happens to both parents, is there someone that you want to designate as being able to be their guardian, right? In the absence of you picking someone or nominating someone, a court may step in and appoint someone else. You may also see wills that have a whole bunch of different testamentary trusts. And these can be really beneficial if you want to give to someone in your will, but maybe there's a reason you don't want them to just get a chunk of money. So sometimes it's because you want to provide for children or grandchildren or minors. Sometimes it's you want to provide for someone who maybe is not the best at managing money, or someone who has a lot of creditors. So that's something that I would say, start to have those conversations. Does it make sense to have a trust as part of your estate plan? So trusts are something I get a lot of questions about. A lot of people who watch Susie Orman say, I need a trust, right? Susie tells me I need a revocable living trust or probate's going to be horrible. So trusts are just a estate planning tool that can be done instead of a will or in conjunction with a will. And it's just a different arrangement where you are picking someone to manage assets for the benefit of someone else. And as I mentioned, probate in Washington is not as horrible as people may make it out to be. So a trust may or may not be appropriate under your particular considerations, but it's something to think about, right? See if it's a good fit for you or your family or whoever you're speaking with. Basic trust arrangement, the person establishing the trust, the settlor or the grantor, transfers property into the trust for a trustee to hold on to and manage for the benefit of a beneficiary. So this is kind of the very basic trust structure. And just know that there are dozens and dozens of kinds of different trusts that can be established for different purposes. Trust and setting up a trust is usually something I recommend you do speak with an attorney about, just because there's a lot of different options, a lot of opportunity to go wrong, unfortunately. I get a lot of questions about revocable living trusts, right? Is it appropriate for me and under the circumstances? Personally, I tend to recommend revocable living trusts in a couple of different instances, right? Maybe your priority is to avoid probate. You want the privacy. You don't want court oversight handling your affairs. So maybe you establish a revocable living trust during your lifetime. The caveat to that is that in order to avoid probate completely, you need to make sure that all of your assets have already been transferred into the trust before your death. So that can be hard to keep track of. Maybe you buy a new car, you sell your house, buy a new one. So sometimes it's a little bit too much burden than you may want for your estate planning. A trust can be a beneficial estate planning tool if you own real estate in several different states. That's a good reason to maybe set up a trust. And then I also tend to recommend trusts when I'm working with a blended family, right? Maybe we have a second marriage for people, they have children from prior relationships. We want to make sure that we're providing for maybe our spouse, but also providing for our children. So there can be some really good reasons to set up a trust. It is not one size fits all. It is not the perfect estate planning solution for everyone. Trust can also be important or kind of helpful for your estate planning if there are going to be gifts to minors, or maybe you want to provide for a beneficiary who is unable to manage their own affairs or is irresponsible. Think about yourself when you are 18, or think about an 18-year-old you may know, right? Would you trust them to inherit a large chunk of money, right? Maybe gone within a couple of weeks if you do that. So there are different ways that we can set up trust to protect that beneficiary. You also want to look at, is your estate going to go to someone who's maybe receiving government needs-based benefits? Then maybe looking at estate planning and a special needs trust can be helpful. Do you want to gift to someone who has a lot of creditors coming after them? There are all these considerations to think about if it's worthwhile to actually set up a trust as part of one's estate planning. I also get questions about setting up a trust to avoid estate taxes. So there are some ways to do estate planning to avoid estate taxes, but I also want people to keep in mind what estate taxes actually are. So for 2020, if you passed away this year and you are in Washington, you can gift almost $2.2 million as part of your estate before any estate taxes may be due. At the federal level, you can have over $11 million in your estate before federal estate taxes may be due. And then you can also gift as much as you want to your spouse, to charities, to certain political organizations without any estate taxes. So for the majority of, I would say, normal people, estate taxes may not be a huge concern, but it's definitely something to make sure you understand and kind of look at what are the assets in someone's estate, and are estate taxes potentially going to be an issue? So before I kind of jump into the next section, I just wanted to stop and see if there were any questions that came in on that topic. Okay, feel free to interrupt me. I think Beverly is monitoring those, but I will kind of jump into the next section and we'll go from there.
Do you have a second for a few questions?
Yeah, please.
You were flowing so nicely. I didn't want to interrupt.
I know.
We do have a couple questions. The first one is about folks that might not have family or friends that are close to them, maybe even that live geographically near them. Do you have any suggestions for how folks can engage in this process without being able to delegate to kind of the traditional folks you would?
Yes. So we're seeing that that's more and more often, right? That maybe our family or friends, we don't want to burden them with the responsibility of handling an estate, or maybe we don't trust them, or we just want to hand this over to a professional. So there are professional organizations that will serve as the personal representative of your estate, that will serve as your power of attorney, which we'll talk about in a little bit. They charge, right? They charge kind of similar to an attorney where they maybe get paid by the hour. But that's a good way if there's just not someone that you want to put in that role. You can start to engage and kind of research these professional fiduciary organizations that you can nominate in your will that will kind of handle all the details. And so if that is something that you're interested in, I recommend kind of doing that research, maybe starting that relationship with these organizations, and making sure that it's a good fit, that you would have them or kind of trust them to handle everything instead of having someone, nearby, a friend or family member, handle all of this. I will also say that with technology these days, if there is someone that you want to name as the executor of your will and they live somewhere else, they live on the East Coast, that isn't horrible. It's still very manageable for them to handle things. It's a little bit easier if they're close by, but it's certainly not impossible. And these days with the pandemic, we're all learning how to work remotely.
That's true. It does take some creative problem solving. So some folks have some questions about the kind of finer points of who fills what role. So one person is interested to know, can a trustee be a beneficiary of the will?
Yes, so good question. So yes, with a trust, you can have, if you're creating your own trust, like a revocable living trust, you can be the person creating the trust, the trustee of the trust while you're alive, and the beneficiary while you're alive. Same thing with a trust or a will, right? You can nominate a personal representative who is also a beneficiary of your estate. That's perfectly fine.
Okay. Someone has a similar question. They're curious if your will contradicts the beneficiary listed on an account. Which one supersedes which one?
That's a really good question. So we actually have law on that. We have some statutes in Washington. And so I will say generally, whichever is the most recent is going to control. And there are obviously some caveats to that. And, some people in their wills try to get really specific that they want certain accounts to go to certain people. I generally try to tell people just keep it more in general terms, right? You don't want to have to keep updating your will with all of those formalities, every single time you want to change a beneficiary. So sometimes it's better to defer to those beneficiary designations. But again, if there's a conflict, usually the most recent is what is going to control.
That makes sense. So someone is curious about, if you do have an account that is an individual non-joint account that's transfer on death, but you're married, would that be considered community property, or would it be transferred directly to the named beneficiary? Does it transfer on death of both spouses, even if it's an individual account?
Really good question. So yes, community property in Washington creates some complications here. So unfortunately, there have been some conflicts. Maybe someone has a community property agreement and an account where they've designated someone else as the beneficiary. There is a lot of law and unfortunately a lot of court cases that kind of address that scenario. So that's where I would say it's really helpful when you're talking about these things. Dig into the details, kind of get a hold on all of the different assets, how they're titled, to make sure that they're not going to conflict and you're not creating conflict down the road.
A lot of moving pieces there.
Yes.
Someone is curious, should we have backup parties for our trust appointees?
Yes, I always recommend having backups. And the reason for that is maybe you designate someone and they die before you. Maybe they just don't want to take on that responsibility. The more that you can kind of build alternates into your estate planning and have backups to the backups to the backups, that usually alleviates the need for court intervention or for any kind of dispute about who should take over control. So lots of people kind of build in your order of priority. That's perfectly fine.
So would there be any benefit then to splitting duties? Like should someone's child's guardian not be in charge of the trust? Would it make sense to kind of delineate that?
It really depends on the people and how you think they will work well together. You know, I have some clients that say, I want a little bit of a check and balance, right? And so maybe they will designate two different people in roles that they're going to have to work together. Other times they may trust one person to handle everything and they're comfortable with that. They want to make it easy. So it's very much a personal choice.
Oh, that makes sense. So it sounds like we do have some folks that are interested in that estate tax exemption. So we've got some big spenders in the group. Some folks that are curious, is that Washington state exemption amount of the roughly 2.2 million, does that need to be gifted before death?
No, so that is when someone passes away, we kind of look at their total estate that is being transferred by operation of their death. And so, one way to reduce the, possibility of estate taxes in Washington is to do strategic gifting during your lifetime. We're going to talk about some caution with that when it comes to Medicaid planning. And of course, these days with real estate prices being crazy, you may be able to hit that threshold pretty easily. But again, that's something where, as an estate planning attorney, I'm talking with clients, we're kind of getting a handle on their assets. Sometimes it makes sense to pull in a CPA or an accountant that's working with them, and we can kind of put a bigger financial picture together.
Okay, so we have a related question. Someone is asking, what should a client bring to their attorney if they don't have life insurance, no LTC insurance, but have managed to save 5 to 6 million? They might spend it down to zero or at least below 2 million by their date of death, but they also might leave earlier than expected and wind up at least taxable in state.
And I think it's totally a personal kind of decision. I have some clients that say, I don't care if the state gets something. And I have other clients that say, I want to make sure they don't get a cent. And so it can be really hard, right? We don't know how long that money is going to last. We don't know when we're going to pass away. And so sometimes when I'm looking at an estate planning client's kind of financial picture, we may recommend, investing in long-term care insurance or some other financial products that just make sense to alleviate the possibility of a big tax bill. But everyone's a little bit different. We kind of put the pieces of the puzzle together and see what makes sense for their priorities.
Yeah. So here's a question actually I have as well. If you do have debt, what's the relationship between those assets and that debt? Does that get deducted from the money before it goes to your beneficiaries?
Oh, yes. So the kind of short answer is when we're settling someone's estate, debts get paid first, right? So the IRS is going to get paid before the beneficiary.
They always do.
Yes. And most debts are going to get paid, funeral expenses, costs of administration. There's kind of an order of priority to make sure that debts get satisfied before beneficiaries are getting their share. So that can be important to kind of get a handle of how much debt is out there before we start gifting as part of the estate. And that's part of the probate process. There's a process to give notice to potential creditors to make sure you have some certainty about the claims that may be out there and make sure that those are resolved before gifting to the beneficiaries under a will or other estate planning tool.
That makes sense. So let's see. So we've been talking a lot about Washington. Someone is kind of curious if they just recently moved to Washington and took care of that will and those documents out of state. Do they need to redo it now that they're here?
Good question. These are all really good questions. You all keep me on my toes. You know, generally, if a state was, or a will was legal in the state where it was made or where the person resided when they made it, then it's going to be honored by other states. I do, though, recommend that if you have a will or a estate planning document that was done in a different state, it's helpful to have an attorney do a quick review. Sometimes the formalities are a little bit different state to state. You may not want to have to jump through hoops down the road, or each state may have kind of its own benefits to gearing their estate planning under that state's laws. So it's not, you know, ineffective because it was made in a different state, but you may want to have a local attorney take a look at it just to make sure that you aren't missing anything big.
Well, it couldn't hurt to spruce your documents up every couple of years anyway. Might be a good time to take a fine-tooth comb to the whole thing and see what else has changed.
Exactly.
Speaking of moving around a little, one last question before I let you get back to your presentation. Someone's asking about maybe bigger moves like across country borders. How does that influence inheritance? Like if someone, the person that they're the beneficiary for is in Canada, for example.
Yes. So every country is a little bit different. And so there are different considerations when a beneficiary is in a different country than if property as part of someone's estate is in a different country. If you own real estate in more than one country, unfortunately, I highly recommend that you consult with an estate planning attorney in each country. Because every country has its own process and requirements and formalities for making estate planning documents. I'm handling some estates right now where there's a property in the UK and there's property in India, and it is not the easiest or most streamlined of processes. So
what a problem to
the
have.
the more borders that come into play, I would say you may want to get some experienced counsel on board to help you with that.
Okay, well, I'm going to hold on to our next few questions so I don't hold you up too much in your presentation. Thanks, Elizabeth.
Yes, and there's a lot, right? There's a lot of little details. So this is hopefully enough to kind of pique your curiosity, do some additional research, and start to have these conversations. And one of the kind of tougher conversations, I think, is talking to loved ones about planning for periods where they may be incapacitated or unable to manage their own affairs, right? I get a lot of calls from people that say, I need a will, but they haven't done any thought about putting in place a durable power of attorney. So I want to talk briefly about what is a durable power of attorney, why should you have one, or encourage especially your parents to maybe have one, because a will or a trust or whatever it may be usually doesn't take effect until someone dies, right? Just because you're named as the personal representative on a will doesn't mean that you have any authority to act on someone's behalf while they're alive. So doing this kind of lifetime planning and putting a plan in place so that if someone loses capacity, is unavailable, is unable to manage their own affairs, right? We want to be able to point to a durable power of attorney and be able to clearly see who has authority to step in. If you're thinking about, powers of attorney are only something that older individuals need, I need to talk to my parents or my grandparents about this, but I don't need one. I caution you that everyone should have a power of attorney. I have a client who was out of the country at the beginning of the pandemic and was stuck in another country for about 4 months. And so he had designated a power of attorney who could handle his finances, get his mail, make sure his bills were paid, and kind of do things locally, even though he fully had, capacity. So powers of attorney are a huge part of estate planning and can really make things a lot easier if a loved one is going in and out of periods of capacity, or maybe they've been diagnosed with dementia or Alzheimer's and are losing the opportunity or the ability to kind of manage things themselves. So at its very basic level, a power of attorney is a legal document where a principal, the maker, is designating someone to act as their agent. So sometimes you hear it, I'm designated the agent or the attorney in fact, or the power of attorney. That means that that person is chosen to be able to step into the shoes of the principal and basically act or make decisions on their behalf. Washington, our powers of attorney are governed by statute. You can look at the Revised Code of Washington, Title 11, Chapter 125, and kind of go through all the default powers or the scope that a power of attorney can have. You can pick kind of anyone that you want to act as your power of attorney. So you can pick a family member, a friend, a trusted individual in your life. And then as I mentioned earlier, you can also designate a professional fiduciary company. So maybe you don't want your family members to kind of get involved in this kind of decision-making or managing your finances. Maybe you want to defer to a professional. You can certainly do that. But again, I always recommend that you build in several alternates. So especially for a financial power of attorney, if you designate only one agent and that agent passes away or is unable to act, then unfortunately a guardianship may be the only option if you lose capacity. So we want to avoid that at all costs. So put your kind of order of priority in those durable powers of attorney. When it comes to powers of attorney, especially if you're someone who is designated as the agent under a power of attorney, one big thing to pay attention to is it effective immediately or only effective upon incapacity? So the maker has that choice. Do they want, as soon as they sign that document, for it to be effective so that the designated agent can step in and act at any time, right? So the scenario where I had where client was abroad unexpectedly for multiple months, his power of attorney was effective immediately. And so it was really easy for his designated agent to be able to step in, get access to bank accounts and make sure bills were getting paid. You can also see or have a power of attorney that is springing, which means it only springs into force at the happening of some event. And usually that event is the incapacity of the principal. So a power of attorney, your authority under it may be contingent on getting like a letter from the maker's primary care physician stating that that individual no longer has the ability to manage their own affairs. I will say that a lot of physicians are kind of hesitant to put that determination in writing. So in an emergency, sometimes it can cause a lot of delay to try to get that kind of triggering letter for a power of attorney. So think about, who's named under a power of attorney. Is it someone that you trust and would trust now, whether or not you've been declared incapacitated? Very basic level, a power of attorney does need to be in writing, and it either needs to be notarized or witnessed by two individuals. I usually say that having it notarized is preferable because if that durable power of attorney has to be used to buy or sell real estate, title companies want to see that it's been notarized. Again, the powers, kind of default powers, are provided for in statute, but you can also add or change those powers as you see fit, kind of detail them in the document itself. There are some powers that you have to specifically provide for in your power of attorney in order to give your agent that authority. So things like giving your agent the authority to make gifts out of your estate or to change beneficiary designations on your account, that authority has to be specifically listed in the durable power of attorney document, or else the agent won't have that. So that's where it's important to kind of go through the different powers, make sure that you're comfortable giving someone that authority. So you may see that there are kind of big power of attorney documents, or you may see two separate powers of attorney. So generally I do two separate ones, right? A financial durable power of attorney, and then one for healthcare or medical decisions. You may not trust the same people to manage your finances as you manage your healthcare decisions. So a financial durable power of attorney covers everything, property, right? That they're able to maybe write checks out of your bank account, make sure your bills are paid. They could buy or sell real estate, get added to accounts as kind of a signer to that account. And they're responsible for managing your finances or carrying out your wishes to the extent they know them when it comes to your property. There's also a durable power of attorney for healthcare, right? So that if you are unable to give informed consent for your own medical care, who do you want to be able to step in and give that consent on your behalf? So where there's no kind of default statute for financial decision-making, there is for healthcare decision-making. So in the absence of a power of attorney for healthcare, Washington does have a consent statute, which kind of lists the order of priority, right? Who can medical providers turn to get informed consent if you're unable to give it yourself? So you may want to check out that statute, kind of see if you're comfortable with that order of priority. Even if you are, I do recommend putting in place a durable power of attorney for healthcare decisions, just so that there's no question. It's one of those documents that I usually recommend once you have one, bring it to your next doctor's appointment, have them add it to your medical record so that if there ever is an emergency, they already know who has authority to give consent on your behalf. Kind of along those lines, and I think this is a topic for People's Memorial presentation tomorrow, so I'm just going to dabble, but advanced directives or healthcare directives, some people may know them as living wills. Generally, they're any sort of document that you are expressing in advance what kind of medical care or treatment or interventions you may want in different scenarios. So a lot of times those are triggered by a terminal illness, a permanent kind of coma, vegetative state. What kind of interventions do you want when end of life is apparent? So a healthcare directive is a little bit more broad. It's what do you want to happen if you're diagnosed with a terminal or permanent condition and you're unable to express your wishes. You may also be familiar with a post form, which is something that a maker will speak with their physician about. Kind of both will need to sign off on that. Something to talk about with loved ones, maybe aging parents. Have they had that conversation with their physician? Do they have a post form or a DNR as part of their medical records? What kind of decisions would they make if they were faced with a permanent vegetative state? So lots of things to think about. Washington does have kind of a basic advanced directive that you can find by statute, but there are a lot of great free resources out there online, great organizations, both nationally and based in Washington, that will kind of guide you through making those decisions. The one tip I would say when it comes to medical decisions and advanced directives, let your loved ones know now, right? It can be really difficult for someone to make these decisions on your behalf. It can be a heavy weight. So if you've already expressed what you want, it's going to be a lot easier for that person to be able to carry through with your wishes. So I know we're going right through it. I have a short little segment at the end, but I'll stop here and kind of see if there are any questions about powers of attorney.
Well, let's take a quick look. Yeah, people have so many questions for you. Oops. My phone was trying to help. Let's see, power of attorney. Are there any online forms that you would recommend for setting up a power of attorney?
So there are a lot out there. I'm probably biased, right? There are some great ones that you can get through, I think, the University of Washington Law School. Seattle U Law, I believe, has some forms. The big question is, will a financial institution accept it? And I will say sometimes I run in working with attorneys, in fact, that they get a lot of pushback when powers of attorney are just kind of printed online and check the box and sign it. You really have to just be comfortable with what you're putting in place. So I recommend doing a little bit of research. Don't use the first form you find out online. Read up on the statute and the authority that you can have in a power of attorney, and make sure that any form that you do get kind of fits your particular needs. When in doubt, talk to an experienced estate planning attorney.
So one of the participants wants to know, does your POA have to live in the same state or same country as you?
No, it does not. I have run into some issues where your designated POA out of the country has been an issue for some financial institutions, but generally you can designate anyone. If they are in a different state, usually not a problem. Again, with technology, they're able to kind of jump in and act quickly if they need to.
Makes sense. It looks like that piggybacks nicely onto another question where someone was asking specifically about a will, but a similar situation as perhaps the person they've designated does live overseas. Are there any positives or negatives to having one person that lives close to you designated and maybe someone far away, maybe strategizing like that?
Yeah, I think that can be helpful, right? Again, build in a couple of alternates so that if the time someone does need to act, it's just not logistically feasible, that they can step down and the next can jump in. Again, I totally recommend build in a few people at the very least, so that if it is an issue down the road, you've already got your backup ready to jump in.
No, it's always good to have a backup plan. Okay, one more question before I let you get back to what you're doing. We're running a little short on time. So someone, in light of the fact that we're also spread out and you might have people designated all over the place, someone wants to know what you would recommend for storing wills and power of attorney documents, advance directives. You want everybody to have access to it, but you want those documents to be secure. Do you have any recommendations?
Yes. And so that's, you kind of jumped ahead to one of my points, but big thing is communicate with your designated individuals where you are keeping the original. So you may keep the original will in a safe at your home. I've had some clients who put them in the freezer. Let your designated kind of personal representative or agent know where they are, but also make sure it's somewhere that's accessible, right? In an emergency, if you keep everything in a safe deposit box, it's going to be really difficult and time consuming for someone to get access to that. So you may want to give them a copy, but also let them know where the original is being stored.
That's a good strategy. Okay, well, I'm going to let you get back to this.
So the last part is a little bit, it's shorter, and I realize there's a lot to cover, so I'm sorry for going a little long. But I think the last kind of topic to think about is, in my opinion, the best, right? Planning to live a long time, right? We want everyone to live long, full, fulfilling lives, but we also need to plan for that. My husband always says, I hope my last check bounces, but not everyone is as carefree as that. So sometimes part of estate planning and having these conversations with loved ones, you get into kind of the icky territory of talking about finances. But financial planning can be really important as part of estate planning and having these conversations, right? What does someone have available to pay for their care? As we age, costs of care and medical treatment tends to increase. Do they have resources available to pay for that? And if you are designating someone as your agent under a durable power of attorney, right? If they need to step in and act, what assets are they going to be able to tap into to pay for your care? So if you're meeting with an estate planning attorney, they're probably going to start asking you some uncomfortable questions about your assets and your finances. All of that is to get a big picture of how do we put a good plan in place as you age. So you can talk to your loved ones about their assets, right? Their health status or diagnoses, and then what do they want for their future care, right? Having these conversations with parents, if they're unable to care for themselves, do they want to stay in their home as long as possible? Are they comfortable moving to an assisted living community? Kind of what assets are out there to help carry out their goals? It's really expensive as you get older. So what are their priorities? What are their financial plan to fulfill those priorities? So starting to have those conversations. I also get a lot of clients who will call in maybe on behalf of a parent or a loved one, how do we pay for long-term care? So I think as someone mentioned, there are long-term care insurance kind of financial products out there. That's something to look into. Read the fine print really carefully about when those benefits can be triggered. And also, I'd say be careful about planning or kind of relying on government assistance. So Medicaid is a combined state and federal benefit that will cover things like long-term care or assisted living, nursing home coverage. If someone has the kind of physical and medical needs, and they also have depleted their assets so that they cannot pay for that care themselves. So unfortunately, I get calls from people that said, oh, I was helping my dad with long-term care planning, and we want to get him qualified for Medicaid. So he transferred, he gifted his house to me and wrote me a check for $20,000. Well, Medicaid has a 5-year look back period. So they're going to say, did you gift away assets or sell assets for less than fair market value? Did you give away things that you could use to pay for your care now? That may compromise their ability to get Medicaid coverage. So if part of your estate planning or kind of having these conversations with parents is looking at Medicaid as a way to pay for long-term care, I recommend you work with an experienced Medicaid planning attorney and kind of making sure that that puzzle and that plan is in place. Because there are ways to strategically kind of set someone up to receive Medicaid, but there are a lot of ways to go awry. So you want to be careful about that. So I'll take questions at the end, but I just want to give you a couple of tips right now. Thanksgiving is coming, the holidays are coming, even though we may not be physically with our loved ones, it's a good opportunity to start having these discussions. Talking to loved ones, hey, I did my estate planning or I went to the seminar. Do you have estate planning documents in place? What do you have? What works for you? Starting that conversation is kind of half the battle. Making sure if they have done estate planning in the past, it's a good time to kind of pull those out, especially if it's been a few years. Do they still make sense? Do they still accurately reflect someone's wishes? Can they understand the crazy complex trust that they set up a decade ago? So all of these things are important. Kind of take a look at what someone has in place and have those discussions about maybe where they're missing some pieces of the puzzle. Also important, especially if you're doing your own estate planning and you've designated a friend or a loved one as your power of attorney or the personal representative in your will. I generally recommend that you ask that person if they're okay being listed, right? It can be a little bit of a shock if there's an emergency situation and suddenly someone finds out that they may have this huge responsibility. So having these conversations early on, making sure that your designated agents know your priorities, your goals, kind of why you picked them for that role that can be an important topic to kind of start that flow of communication. So talk to loved ones. I know it's uncomfortable. You can use me as an excuse. Say you listen to some crazy lady talk for an hour about estate planning and you want to ask them some questions about it. When it comes to end of life and medical decisions, you know, having these conversations now when someone is hopefully healthy and has the cognitive ability to think through these issues, that can be really important so that you know kind of when you should step in to act and what someone's wishes are down the road. So have these conversations. If it's over Zoom, over the phone, just kind of start that flow and make sure that you're comfortable with your own estate planning and then helping your loved ones as well. So we kind of talked about this as well, that let people know where you are keeping these estate planning documents. I have some clients that go, oh, I got a death folder in my file. You know, if I die, open this, whatever works for you. Just make sure that those people you trust, your designated fiduciaries, that they know where to find this important paperwork. Let them know where it is, tuck it away, and then try not to think about it or worry about it too much. With that said, any kind of questions that we didn't quite cover? I know we're running short, but I'm happy to answer as many as we can.
Well, we are a little bit over time, and I don't want to hold folks up too much around dinner time. It's a good way for your audience to turn on you. Yes. So I was thinking that maybe we go ahead and in my follow-up email that I'm going to send out to everybody, maybe we include the answers to some of these other questions that we haven't yet answered. And that way you can just write a little response and I'll include that in there for them, as well as a copy of your recorded presentation and the slides you shared. It's a wealth of information in there. I'm also going to go ahead and include in that follow-up a copy of our ducks in a row checklist, as well as a designated agent form and a disposition authorization, just to kind of help folks get the ball rolling on some of the things they should be thinking about. Part of our vision for this supporting the supporters series this month is we know a lot of us are going to be having those awkward conversations with our families. I'm sure we've all had that same experience where your family hands you the sticky notes. And as awkward as that is, it's such a great gateway conversation into the stuff that Elizabeth's been talking about today. We all want to have the conversation. It's just tough to figure out where to start. So hopefully some of this information can help you have a little bit more of a productive conversation with your family this holiday season. Thank you so much, everybody, for joining us. And like I said, keep your eyes peeled for a follow-up email. I'll make sure you have contact information for us at PMA, as well as for Elizabeth. So that way, anything that pops up later in the middle of the night, we'll make sure that you get the answers you need to your questions. And thank you so much for the active participation. There's so many good questions in here we didn't even have time for. Thank you again also to King County Library System for making this session possible, and for Elizabeth for generously sharing all of her expertise. You guys got a real treat here, getting all of these questions answered. So thank you so much for joining us. And I'll go ahead and have our panel stick around for a little bit so that we can have a meeting after all of our attendees are gone. Thank you so much for joining us. It's been a pleasure.